Hello friends, how are you? Today I am going to discuss an important judgment of Honorable Supreme Court of India. The judgment which has given a better way to the concerned public servant against the departmental inquiry. As we know that it is very much easier to face a criminal case or a civil case, but it is very much difficult to face a departmental action because the allegations once proved. In that scenario, you might be subjected to minor or major penalty, and sometimes they may end in termination of your services. So if you want to parry such type of problem in that scenario, you must study the recent legal position and you must know about your rights so that you could easily contest such type of cases. You got the point now it is easier. So in that sequence, I am going to discuss the recent judgment of Honorable Supreme Court, which has been pronounced in a case titled as K. Charaiya versus Mohammad Nazar. The concerned appeal number is 19916/2023. Judgment has been pronounced on 23rd of September 2024. In that case, we have to take a story for the better understanding. In that case, there was a person named as Mr. A, who was a judicial magistrate. He was appointed and he was discharging his duty in honest way. He had decided a case wherein he has convicted certain persons who had filed the submission before the Honorable High Court. And their prime submission is that the concerned judicial magistrate acted dishonestly while acting as a judicial magistrate or while discharging the judicial duties. Because being a judge, it is a duty of the concerned magistrate to consider entire scenario of the case in the light of law so that the right conclusion could be driven. But in that case, without examining the concerned IU, without giving the opportunity of being heard, which is a basic right of the concerned accused person as enshrined as per Article 21 of Constitution of India, which also includes the right to get a natural justice, is not given to them. And that's why the orders are illegal, and apart from that, they are requested to initiate proceeding against the concerned magistrate for the culprit act done by the concerned magistrate for not following the procedure of law. In that case, while hearing the entire case, the concerned court had passed the following order on 14th of December 2022, call for the record, in the sealed envelope manner. After that, the case file was posted for the further hearing and date was given 5th of January 2023. In the meanwhile, the matter was prepounded without assigning any reason, and finally the matter was listed on 23rd of December 2023, and finally the order was passed to the concerned authorities to put the concerned magistrate under suspension, and apart from that, the direction has been given to initiate the departmental proceeding. And after that, the concerned magistrate has challenged the proceeding because it is a right of every person, including a magistrate, including a prime minister, that in case of any prejudice, in case of any order which is going to be affected them in any manner or him in any manner, whatever the case may be, in that scenario, the order could be challenged, and he is also challenged the order. Okay, na? And finally, the review petition against that order has been rejected, wide order that has been pronounced on 21st of June 2023. And finally, both the orders had been challenged by the concerned judicial magistrate before the Honorable Supreme Court. He has raised the following 10 contention before the Honorable Supreme Court to challenge the impugn order, and request was also made to set aside the order being perverse, abuse of process. The prime contention is that I am a judicial magistrate. In my whole career, I have not violated any provision of law. I have done my duties with utmost sincerity. And if any malafide act had been done by me in that scenario, proceeding would be initiated by the concerned High Court in nature of criminal proceeding. But no such proceeding had been initiated. And apart from that, proceeding that had been initiated in nature of Section 340 CRPC and Section 195 CRPC had been dropped. So the same was considered as a better point in favor of concerned judicial magistrate. Apart from that, he submitted that it is a basic right of a judge to decide the matter evidence available, and I have decided the matter as per evidence available as per the judicial discretion. No dishonest act had been done by me, and apart from that, I have not abused my judicial duties. Third contention is that the matter has been listed on 5th of Jan 2023 as evident from the record, but suddenly the matter is preponed without giving me any advance show cause notice. That is showing the illegality in the proceeding, and that point is required to be considered seriously. Number 4, I had been directed to provide the consent Honorable High Court the record of the concerned case in sealed envelope manner, and I had dispatched the concerned envelope in the sealed manner, and the same has been received to the concerned institution on 26th of December 2022, and before that listing of the case and passing the order without having any final adjudication until going to affect by right. Number 5, there is a violation of rule of natural justice, because every person has a right to be heard in support of his case, but no opportunity has been given to me to sustain my cause, and that's why entire proceedings are illegal. Number 6, the proceedings in nature of natural justice are imperative, and the same is part and parcel of Article 21 of Constitution of India. If no opportunity is given to me, in that scenario my rights had been affected by the concerned institution. Number 7, there is no iota of evidence that I have discharged my duties in the illegal way, and it is admitted position that on 26th of December the record has been received to the concerned High Court, and before that passing order of departmental action, it means on 23rd of December, is totally wrong. Number 8, the concerned order had not been decided finally, which had been challenged by the concerned culprits by assigning that I had discharged my duties in illegal way and they had been wrongly convicted. If they are wrongly convicted, it is a prime duty of the concerned court to decide the matter and to find out who is the guilt on the basis of evidence available, but no such effort has been done. Number 9, I have also challenged the concerned order by filing the recall petition, review petition, but they had not been considered. And point number 10 is that while acting as a magistrate, I have discharged my duty in a right perspective, but in the anxiety the concerned higher authority had acted, and inter alia great prejudice had been caused to me. So all facts and circumstances, the Honorable Supreme Court had discharged the concerned accused from the charges, which is usually termed as exoneration, and finally set aside the departmental inquiry on the ground that there are 2 violations. Number 1, the opportunity of being heard is not given before listing the matter on the prior basis. Number 2, when the record had been received to you, means to the High Court on 26th of December, then how it's possible to pass the order of suspension on 23rd of December, and apart from that, which also include the proceedings of departmental action against the concerned magistrate. So this judgment is important, and apart from that, it is a path-breaking judgment, because sometime it has happened that our concerned inquiry officer or concerned higher authority used to act in anxiety, or they entirely target us, and without giving us the opportunity of being heard in the proper perspective, they pass the order. So if such a scenario occurs in your case, you may challenge the same by relying on the said judgment, and that's why I had termed the same as a path-breaking judgment. So I hope and I understand that you all will be benefited by the said judgment, but thing is that you have to do proper study, you have to make the proper brief of your case, and apart from that, you must be able to understand the basic nature of your case. If you are not able, then you could not be succeeded. So remember all this point, make the proper brief, make the proper research work, apply the same to make the proper documentations for filing, so that you could get the optimum results before the concerned authority which had been initiated the action against you. Because in that case, he had lost everything, his job, and apart from that, he has not lost one thing, that is hope and trust. So trust on our legal system, and apart from that, raise all the contentions as you can, and apart from that, in addition to this, you are also advised to make the brief synopsis, so that while arguing your case, you could directly highlight the judge on these points as well. So see you in the next video. Till then, Jai Hind, Jai Bharat.